So there's different circumstances under which people move. There's, first of all, during the school year versus during the summer, different rules apply. And then the smallest move would be within your district and just to a different school. And really there, they just have to keep implementing your IEP as it's written. Nothing really changes. And then there would be without the district, but in the state. And there, the district basically has to implement your IEP as written, and they can either permanently adopt it or they can adopt it for 30 days and offer comparable services, which means equivalent or similar, while they're developing a new IEP, okay? And then when you have that IEP meeting in the new district in the same state, if you disagree with what they offer, you can invoke stay put. But of course, you get into interesting discussions about what the stay put will be if you move far enough away so that, let's say, the school you were going to is now 250 miles away. This is a really pretty crazy area because there's so many rules. And then if you move out of the state, they have more discretion to do basically whatever they want. They can decide to start all over again with eligibility. They can adopt the IEP from the new district and do the 30-day thing. They really have pretty unfettered discretion, which I think makes some sense if you think about it, just because they're a different state, they're very far away, and so on. And one thing I meant to mention is when you go from District A to District B, if you have an IEP you've never signed and it hasn't been implemented, you can't demand that the new district implement it. It has to be an implemented IEP. So we get into lots of discussions about what's going to happen because you can see there's not really any conformity of opinion. The districts don't understand this either. If you move in the summer within the state that you live in, the rule is that there has to be an IEP in place for you by the first day of school, and they're going to have to use probably things that were done in the prior district. Now, this is where most of the litigation I've been involved in has developed, where, let's say, parent moves from Santa Monica to Palo Alto, and Palo Alto doesn't have an IEP in place for the first day of school. That's illegal. They have to have an IEP in place. Doesn't mean they have to conduct assessments. It doesn't mean they have to have a meeting, but they have to have a plan in place. So that brings us to the question of what triggers the duty for them to do anything. And the answer is there's no duty until you enroll in a new district, so be aware of that. And then once you enroll, the other thing that's important is getting your records to the new district. So the old district has a duty to send the records without delay, and the new district, has a duty to seek out those records. And I also wanted parents to know there's not a duty for the sending district to send everything. So, for example, disciplinary records are not required and things like that. So always, if you have your own records, making a copy of those may be important to give to the new district. So that's pretty much what I want to say about moving, except for if we have time, I want to tell you what we're going to do in this case that I'm involved in.
Please.
We are going to request an IEP with the new district. We are going to ask the new district to fund the existing placement, and then whether the district says no or yes, we're going to get an expert to go out and look at whatever the district placement, whatever the new district suggested placement is, and also have the expert see the person in the current placement, and then we're basically going to be involved in litigation if we can't resolve it about whether or not this is a comparable program. So it's a bit of an exercise. It's expensive for the family because they have to hire an expert, but they're quite set on the idea that they want to make sure that they can perpetuate the current placement, and that's the best way I can think of to do it. And then my little parting goodie for you is that sometimes when districts find out that you are moving, they are happy to be getting rid of you. Sorry to put it like that, but I think that's an accurate statement. And they may be willing to write lots more services into your IEP so that when you go to the new district, all of a sudden it's like 2 hours of speech instead of 30 minutes and 20 hours of behavior intervention instead of 15 hours of a district aid. So that's a little something you can capitalize on. And I guess the other related note that we found is when special ed directors retire or leave districts, about 3 months before they leave, they start giving away the farm sometimes. So that can be a nice time to be there and be making a deal on someone's behalf. So that's kind of the deal on moving. It's very tricky. There's lots of different rules. You need legal advice before you do it if you want to perpetuate your IEP. And, I definitely don't require committing residency violations. In other words, it's illegal to be taking district services in a place where you're not a resident. And I'm even in possession of a couple cases where some eastern states sued families for repayment because they had moved out of their district but were still getting expensive services in the old district, and the district caught them. So nobody wants to be playing residency games. And, if you think about it, sooner or later, probably somebody's going to, the child is going to say, oh, I don't live there anymore. I live here. And, there's a duty imposed on a lot of the private contractors to inform the district if they find out that you've moved.